2024 at 8:42 a.m.
Good morning to both of you. We're here today for a scheduling conference, and that's where the court puts in place various dates and processes so that the case will proceed in an orderly fashion. First, inquire of the parties. First, Ms. Daniels, do you believe that there's any disputes that you have in this case?
What do you mean by that? Sorry, sir.
Are you arguing or fighting about anything?
Not really. Just the kids, basically. But
Okay. So there is a dispute concerning custody, parenting time, or support?
I got sole custody right now, temporary sole custody right now, because he had a head injury. So.
Okay. Let me ask Mr. Daniel. Mr. Daniel, do you believe that there's a dispute on those issues, custody, parenting time, or support?
Yes, sir.
Okay. Well, with the fact that he has stated that there's a dispute, the court will, in fact, acknowledge that, that there is a dispute, so we will do a scheduling order. Are there any property disputes?
No.
Sir. Okay. Any disputes as it relates to spousal support?
No, sir.
Ma'am?
Kinda.
What?
I said yes. I believe I should get spousal support. Yes, I believe I should have spousal support because he took care of me for so many years, and I finally had to get a job.
Ma'am, I don't need the details. I just need to know if there's a dispute on those items. Okay. When we have a trial on it, that's when we'll address those particular issues.
Okay.
Any other disputes that you can think of, Miss Daniel?
No.
Mr. Edwards? Mr. Daniel?
No, sir.
Okay. What I'm going to do is give you some time for discovery, and discovery is the process whereby you can get information from the other side. If you needed income information or other information, you'd be able to get that. So what I'm going to do is, I don't know if you'll have any, I'm going to give you to July 1 to do that. So you'll have to move rather quickly if you're going to do that. And so what'll happen, that'll means mediation will be in July. Miss Daniel, is there any mediator that you're aware of that you would recommend?
No.
Okay, Mr. Daniel?
No, sir.
Okay. Then the court will the mediation clerk will randomly assign a mediator in this particular matter. I will tell you there is a cost associated with mediation, and it depends on the particular mediator. So I can't tell you what it's going to cost because we simply don't know as to who gets assigned at this particular point. And if in fact you get to a point where you cannot or you don't believe that you can pay the cost of mediation, then you need to get matters resolved or you'll have to proceed with the mediation at that point. Okay, anything else that either of you have?
No, Your Honor.
Okay. What I'm going to do is set up the settlement conference date for August 5th, 2024 at 1:30 p.m. Parties are required to be present, so you will have to be here at that time. And it'll be just like this. It'll be like by Zoom, and then we'll see where we're at that point as to whether we need to set the matter for trial. So we will send you this case scheduling order. It'll go out today, actually. You should get it yet this week, if not the beginning of next week. It'll have all the dates in it that you need to pay attention to. And because some of those dates, if you don't, it'll have consequences to your case because you could miss the dates for disclosing witnesses or exhibits or things that you might need at trial. So make sure that you pay attention to those dates when you get it. Do you have any other questions, Miss Daniel?
Yes, so we're not getting a divorce today. The reason why I asked because I'm gonna have a baby any day now, and my boyfriend can't sign that birth certificate.
Nope, you will not get we can't get divorced until we get the matters resolved. So I don't know when that'll be. It depends on when the two of you can come to an agreement, and you may not be. We end up having to have trials. So I can't tell you when we'll get the matter resolved, but that's up to the two of you. And in this matter, I don't know. I don't have it in front of me because I just signed some papers on this. You have a 180-day waiting period from the time that you filed your complaint. So, and I know you're not into that. You're not past that 180 days because we're just doing the scheduling conference. We do that early. So the court legally cannot sign it until after the 180 days.
So what am I supposed to do when the baby's born then? Because it's my boyfriend's baby.
Well, what you're going to have to do, that does add a wrinkle to the thing. You're going to have to file a motion to determine the child was not issue of this marriage and a child born out of wedlock. So you're going to have to file that motion. And then we're going to end up we'll have to do a DNA test as well. And so
we're already getting it done since the baby's born, sir.
Excuse me?
We're already getting it as soon as the baby's born. We're doing it right in the hospital after it comes out.
Okay, well, that's fine.
Yep.
What we'll do is we'll just have we'll have that hearing, and then you'll be able to, we'll submit the results at that time.
Okay.
Anything else?
No, Your Honor.
No.
Okay. So, Ms. Daniel, when that does happen, you're going to need to file, once you get the report and that, you'll need to file your motion to determine the child is born out of wedlock.
Okay. So when I get the DNA test back, then I file or whatever.
You can file all that paperwork.
And then he'll be able to sign the birth certificate after that, once everything's like.
After we have the hearing, correct. Okay?
Yes, Your Honor.
Okay. You're free to go. Have a good day.
You too. Stay safe. Bye-bye.
AM attorney Jim Jordan for the prosecutor's office.
Okay. Mr. Robb, you are Christopher Robb Jr., is that correct?
Yes, sir.
Mark Christopher Robb, I'm sorry.
Yes, sir.
Okay, you're before the court for arraignment on the charge of violating the personal protective order. In this particular matter, I'll advise you of the allegations. The allegations are that on or about May 28, 2024, that you did, in fact, enter upon the premises of the petitioner.
I walked down the sidewalk because I had an appointment with the Life Recovery Program to fill out an application for.
Okay, sir, I don't need to hear you.
I did not enter. I did not prowl. I was not stalking.
Sir,
I was
okay, just stop talking until I get done, okay? You'll have a chance to talk. I'm just advising you of what the allegations are.
Yes, sir.
The allegations are that on May 28, 2024, that you did enter upon the premises at Haven of Rest in Battle Creek, Michigan, which is the address of the employer of the petitioner, Aaron Robinson, and that you, in fact, remain upon that premises, that you did, in fact, approach her, and that you did, in fact, continue to remain upon that premises, all in violation of the personal protective order entered on February 6, 2024, which is effective through February 6, 2025, by, again, the particulars by approaching petitioner at a public place and then appearing at her workplace as well. You have a right to contest the charges. You have a right to an attorney if you cannot afford an attorney and the court believes it may impose jail time. You have a right to have a court-appointed attorney if you otherwise qualify. You have a right to remain silent and not have that silence used against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to confront witnesses. You have the right to call witnesses in this matter. And you have the right to have the court compel witnesses to appear on your behalf. In this matter, you can plead guilty, not guilty, no contest. How do you wish to plead?
I would plead not guilty.
Okay. And were you looking at having a court-appointed attorney?
Yes, sir.
Okay. We will get you. We'll get you the
I was-
forms. You'll have to fill out the forms and see if you qualify as far as your income in that to qualify for a court-appointed attorney.
I'm just trying to get better on with my life, sir. I have to get to I'm supposed to, even today, like I'm trying to get to the life recovery program to fill out an application. I could care less about all this mumbo jumbo. I will do what I have to follow through with whatever. But still today, I'm trying to get my life on track. I have nothing to do with, I don't have any care to see my ex-fiance or whatever she is. I have no nothing, no care whatsoever to deal with her. I'm trying to get my life on track for a better life
Okay, well,
for myself
none
and
of
purpose.
that helps us today, sir. We're only here to read.
Well, I'm saying, do it. Well, I can't get help today if I'm not released today on a bond or something.
That's true.
I've got property out there that I've still got to handle.
That's true. In this matter, court will need to give you a hearing date. Mr. Flores, did we get a hearing date in this matter?
I do not believe so. Where's one moment, please? Let me check.
Your Honor, in the meantime, the people will represent in this matter
Is it
and
in numbers?
requesting at least
I don't have it. Is it in numbers?
Okay,
requesting 14 days adjourn.
I'll be June 14th. That'd be June 14th at 9:30 a.m.
I can do that.
at what time?
9:30 a.m.
Okay. Okay, Mr. Rob, that's the hearing will be June 14th, 2024 at 9:30 a.m. Do
Yes,
you wish
sir.
to address the issue of bond, Mr. Jordan?
People would ask for $1,000 cash bond on this matter, Your Honor.
Okay. Mr. Rob, do you wish to address the issue of bond?
I would like a personal recognizance bond, and I can pay it as soon as I can pay it on the 1st. Honestly, if I get let go on a PR bond, I can get half of it paid.
Okay, well,
And that's I mean, you guys want me to work and get you your money. I need to be out there to be able to get you your money, and I
Well-
can have it on the 1st. Sitting in here, I'm doing nothing, and I can't do anything.
well, I understand that, sir. Well, what I'm going to do is I am going to close a bond. I'm not going to do as the prosecutor requests. What I'm going to do, Mr. Rob, I'm going to set your bond in the amount of $200. If you're able to post that bond, you'd be able to be released. Do you have any questions?
I'm not going to be able to post that bond, sir. Like I said, I've got other things that I have to take care of. I've got property I've got to handle, and I could get you if I was let go on a PR bond, I could have that today or tomorrow. I'm trying to work with you guys. If that's the best you can do, then I guess that's where I'll stand.
That's the best we can do, sir. Anything else, Mr. Jordan?
No, we thank the court.
Okay. That will be the order of the court. Then you'll be remanded as well. Mr. Rob, you'll have to get fingerprinted in this matter. The court will sign that order so that can
So I'm stuck here until the 14th at least?
You're stuck until the 14th unless you post the bond, correct?
Wow, dude.
And Judge, Mr. Sackrider did join.
I didn't hear anything else. Y'all are all fucked. You don't even know what the fuck is going on out here.
Okay, come back here, Mr. Rob. Mr. Rob, come back here. You don't talk like that and be disrespectful. The court is holding you in contempt.
This is a
of
whole
court.
complete
You're in
disrespectful
contempt of court, sir.
situation.
You will
This is a
serve
personal
3
issue
days
that
in
is
jail.
completely disrespectful beyond all regards.
Keep it up and we can add more time, sir.
Whoa.
Sorry, Mr. Sackrider, didn't know that you were present.
My apologies, Your Honor. I was late this morning. I didn't see the email. It's my understanding he entered a not guilty plea and was given a bond.
Yes, bond in the amount of $200. And as you might have heard, that the court did hold him in contempt of court and put him in for 3 days, but he's also there until the 14th when we could have that hearing.
What time on the 14th?
9:30 a.m.
All right. Thank you.
Okay, thank you. You're free to go. Have a good day.
Thank you.
And just one more thing, Judge, so there's no fingerprints until guilty, so that order will not be,
Yeah, we'll
that
just sign it.
need to be signed.
And will that be in front of you or Judge Yost?
That'll be in front of Judge Yost.
All right. Thank you.
Okay, thank you all. Have a good day.
Yes, like baling hay, sir.
Okay, we're ready for you.
Okay, thank you.
Mr. Bailey, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, sir.
I advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes, sir.
Are you doing so freely and voluntarily?
Yes, sir.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No, sir.
Court will find that Mr. Bailey does freely and voluntarily waive his right to an attorney. Mr. Bailey, I'm going to take some testimony from you and Ms. Platic, so if you would raise your right hand.
In the matter of Hoig versus Bailing. Mr. Bailing is here for an adjourned show cause hearing. Presently, he is ordered to pay $700.50 each month. That's a current support obligation of $647, $50 ordered on the arrears, and then the $3.50 service and processing fee. This is the fifth show cause in this matter. He's had one previous bench warrant and no contempt findings. The last payment in this matter was made on 5/8 of 2024 for $57.57. He did pay that on his own. Compliance was measured over 5 months at the $700.50 per month. During that time, he's paid $1,409.05, which leaves him short $2,093.45 for those 5 months. Current arrearage is $2,681.22 through the end of April. There have been no prior jail sentences in this matter. However, it has been before the referee numerous times when contempt has been stayed. The referee has also adjourned this matter numerous times, and I myself have adjourned this matter now 3 times to allow Mr. Bailey to gain compliance. And we just have issues continuously each month with not meeting that current support or applying anything towards the arrears balance.
Okay, thank you. Mr. Bailey, do you contest or dispute any of the statements made by Ms. Platic?
I believe she is accurate. It's been a little tough catching up with no snow. I do apologize for that.
Okay. And do you have any questions for Ms. Platic?
I don't. I just I spoke with her earlier and got a price, and I had let her know that we were going to make at least a month within 4 or 5 days.
Okay. What can you tell me? Why have you again, looks like you've continued to fall behind on your arrearages. Why is that?
Well, you know, I was working for a company for a while that the child support wasn't being taken. It did get paid. I started my own business to try to eliminate this process. And unfortunately, Mother Nature doesn't like us in the winter. So it was very hard to get through. And the April bills for lawn care came through. We did end up paying a little bit as much as we could. And we did, end up paying in Jackson as well, getting some bills caught up. Bills are coming in at the month end. The first of the month, we get all of our money coming in for our lawn care services that we provide. And I'll be able to make a nice chunk as soon as, the 1st of June gets here and we get things caught back up, because we're really rolling on the lawn care right now. We're getting very, very busy, which is going to help everything.
Okay. What do you, again, obviously when there was no snow, you weren't getting snow removal. What do you make on average per month for your lawn care business?
Let me check with the girlfriend secretary here. What would you think?
Well, say it's about 30.
If you know, sir, just a rough.
I mean, 38 to 4,200 a month.
But that's gross.
And that's gross. That's no overhead, gas, things like that.
And do you have employees?
I have one, which I've unfortunately just cut back 2 weeks ago because, certain bills aren't getting made. And unfortunately, you have to take the cut where you have to take the cut. So now I do go out solo. And I'm trying to make an attempt to get all this taken care of.
Okay. When was the last full-time work that you had at a not being self-employed?
Oh, I would say it would be late 2022. I worked for FedEx Ground, and I started my own business and took off by myself early of 23.
Let me ask you this. If, again, sounds like based on what you said with your gross earnings that are coming in, that they should be sufficient, obviously, to meet your support obligation. And you started that business back in 2023. Why weren't you able to pay in 2023 to the point where you should have?
It was, it's definitely been a building experience. We're getting busier and busier this year, especially. We're up to about 50 lawns a week. So as this was taken off, we have, unfortunately, the mortgage and the gas bills and all the other stuff that comes in. And, we got to make sure that we can have a good home for Parker to come to when he's here. But things are really taking off for the better. This hearing couldn't have happened at a worse time, unfortunately, because like I say, here in the next few days, we are getting ready to make at least a 1-month payment, and we're going to keep doing the monthly payments from here on out, whether it be bi-weekly or if I write a cashier's check once a month straight to the court.
Okay. You understand that Ms. Hogue, she has the same responsibilities you do for mortgage and utilities and all that stuff that she has to pay as well. And she can't do that if you don't pay her support obligation.
Yes, sir.
Okay. Anything else that you'd like to tell me, sir?
I don't think so, sir. Just
Okay.
I'm very grateful for your guys' patience.
Okay.
Things are getting better, I promise you that.
Ms. Hogue, is there anything you'd like to tell me?
Absolutely, if I can.
Go ahead.
Okay. First and foremost, I would like to say he has a boat. He just bought a boat. He's out on the lake every other weekend. We had to sell our boat so we could afford things like our daughter's dance, all of her extracurriculars. I've been patient with Kevin for years. I've had the kids full time since 2018. I let his custody stay at 50-50 so his child support would be more affordable. All he gives me is the same excuses as to why he can't pay. My husband, whom the kids call dad, works now 70 hours a week for Dish Network. I can provide all the proof that you want, sir. And part of the reason for that is because he has to pay for health insurance on Parker because Parker is ADHD and autistic, and he needs special care. So my husband pays $200 a month for that. That doesn't count co-pays or anything else. My husband has been supporting these kids the whole time since we've been together. Today's his birthday. He's working. Yesterday was our anniversary. He works. He works because, like you said, the bills come in. The kids need food, clothing, shelter, all different kinds of things. Kevin has never, ever been responsible. He does not take the kids like he should. My daughter won't even talk to him anymore. And just in the last 10 months, my husband has spent almost $3,000 towards my daughter's, she's in honors choir. So we travel for that and for her dance classes, which she loves. So, he wants my kids to have a wonderful childhood. So he works. And unfortunately, and for Parker, I have to homeschool him. We were in agreement with Kevin and his girlfriend that they were going to help, but they have not helped at all. I can't work. I have to homeschool him all day long. I'm in my car right now because he's inside on a Zoom. But one of my biggest concerns that I've been stressing to Kevin about is Parker needs behavioral therapy. And in order for him to get the right therapy that he needs, it's going to cost money. We have not met our deductible yet, so it's going to come out of pocket, unfortunately. And this is to get him to have more emotional regulation and be able to control himself, to be in a public setting with other students. This is extremely important. I am looking for a part-time job so I'm able to pay for that therapy because it's $150 a session and he needs 2 sessions a week for the summer. I've stressed to Kevin numerous times that we need help. And sir, he does not help. He actually sent me a text message the other day and asked if I wanted his old boat. Said, it just needs a motor, it needs to be cleaned up. And I'm sitting here thinking, we can't even go on a date night. I'm sorry. Because we're taking care of everything, and we always have been. And I've been patient with Kevin. I've been understanding. I've been, okay, this business, good for you, but it's not working. My husband would love to start his own business. He's a very smart man, but he can't. He has to work because bills come in. He has responsibilities. And Like, my husband doesn't have any children of his own, and we can't even save up the money to have a child together of our own because we love the kids, but every single penny, every single thing we have goes to them. And Kevin knows this, and I'm just tired of it. I get no respect. And on top of it all, he makes our lives so hard, sir. He called the CPS and made false accusations. The CPS closed the case because Kevin literally told the CPS worker, you know what, I'm just not even going to take Parker. So just drop it. And you can look that up. But I'm sorry, I'm getting emotional. It's just, I'm tired of the excuses. Your business isn't working. Get a job. Get a job. Support your children. Okay. Period. Thank you. I'm sorry.
That's fine.
Thank
Sometimes you just need to vent those things and
it's hard.
Make them be heard. Okay.
Thank you.
Okay, thank you. Well, in this particular case, the court will make the following finding that Mr. Bailing does have a support obligation of $700.50. It's nominal when you consider yeah.
Oh, I'm sorry. Was I able to speak on that at all?
No.
Okay. Sorry about that.
That again, that's nominal. It's more considering that at least under the order that he has 50-50 custody, which he doesn't exercise, that as Ms. Hogan stated, that she has the children full time. So he's get a substantial reduced. Yes, go ahead.
I'm so sorry, but that just changed, Your Honor. I was taking Parker every other week until the homeschooling started. And then she was supposed to do the school while I go out to work, and I was going to pick him up after. Then she just brings the computer over, says, figure it out. And how am I supposed to pay child support if I don't work? I mean, that was the whole thing. It's definitely been a lot of 50-50. And there's a lot of proof of that.
Okay.
Kevin, you're lying.
Hold on. We've heard the testimony.
I'm so sorry to interrupt.
No. So in this case, the court will note that the respondent in this matter did start his own business back in 2023, that he had supposedly a good job with FedEx prior to that time, but that he quit that to go his own business, that it took some time to develop. He now is doing, as he says, 50 lawns per week. His monthly gross is $3,800 to $4,200 per month. Clearly, court will note that he has sufficient income to pay the support obligation, but he, as he stated, he's paid other things, other expenses of his own, totally disregarding any of the expenses that the plaintiff has in this matter to raise the children. As a result, the court will find that he has not made a good faith attempt at compliance. He's failed or refused to comply, and he is in contempt of court. Anything before sentencing, sir?
I would like to be able to make money so that I could pay. I mean, this is all going to change in less than a week.
Okay.
I really do. I hope that I can, continue to make money. Things are going really well.
Yeah. Well, I'm going to give you that opportunity, although the court does have some reservation about that. What I'm going to do, sir, is I'm going to sentence you to 21 days in jail with credit for no time served, but I'm going to allow you to purge yourself of contempt by paying the sum of $1,000 no later than June 14, 2024 at 4:00 p.m. If you don't pay the purge amount by that date, then you'll have to report to the sheriff's department to serve your 21 days in jail. You understand that?
Yes, sir. That will be done.
Okay, good. Anything else, Ms. Plattick? Okay, thank you. You're free to go. Have a good day, and hopefully we don't see you back.
You won't. Thank you, sir.
Thank you.
Thank you, Judge.
Good morning to all of you, and I appreciate that you're able to accommodate the court schedule and appear early. What we're going to do is take some testimony from all of you. And Ms. Hazelton, is Mr. Hill there?
Yes.
Okay. What I'll do is I'll have all three of you, Mr. Hazelton, Ms. Hazelton, and Mr. Hill, raise your right hand. We'll have you sworn in. Then we'll proceed.
Raise
your right hand. Can't see you, so.
I think he's in the waiting room.
Oh, so he is joining on his own device. Okay, I'm sorry. Is that Chris? What's the last name?
Hill. Okay, thank you. start with you first, Ms. Ootleton. You filed a motion in this matter seeking to have the child determined not to be issue of this particular marriage. Just for clarification, I don't know, how do you pronounce your son's middle name?
Zadif.
Zeta?
Zadif.
Zadif, okay. I'll do it phonetically. Okay. Go ahead, ma'am. You can testify and let me know what you'd like me to be aware of.
So I had a child with Christopher Hill while still being married to Kyle Usselton, but I have filed a divorce and a motion for child born out of wedlock. There has also been a request to default on that divorce.
Okay. Regardless, we're only dealing with the issue of the paternity at this point. So when was the date of birth of the child?
2023 February.
Okay. And tell me, at the time that child was conceived, approximately 10 to, let's say about 9 to 10 months prior to that time, was in fact, did you engage in any sexual relations with Mr. Uselton?
No, sir.
And it says in your complaint for divorce that you separated on or about August 4, 2021. Did you have any sexual relations with Mr. Uselton after that date?
No, sir.
Okay. And at the time of conception was in fact, you only engaged in sexual relations with Mr. Hill?
Yes.
And in this particular matter, has Mr. Hill acknowledged that he is the father?
Yes, sir.
And has Mr. Hill, has he taken responsibility for the minor child?
Yes, sir.
And does he and the child engage in a parent-child relationship?
Yes, sir.
Okay. Okay. Thank you, ma'am. I'll ask you, Mr. Uselton, in this complaint for divorce, she stated that the two of you had separated on or about August 4th, 2021. Is that accurate?
Yes, sir.
And had you had any sexual relations with the plaintiff after that date?
Yes, sir.
You did?
Yes, sir.
Okay. When would have been the last time that you had sex?
It probably have been. Probably it was before Rain was, or she was pregnant with Rain.
Okay, I need a date. I need a date. That doesn't.
I don't know. I didn't keep track of it because to me at the time it wasn't anything that I needed to keep track of, Your Honor. It was yeah, September, October. I mean, it was just a random occurrence.
September, October of
last year. Year before last. Sorry, 22. I'm sorry.
22. Okay.
It was while I was switching up.
Okay. Well, Ms. Uselton, I'll ask you another question because this is contrary to your testimony. Did you in fact engage in sexual relations with Mr. Uselton in September or October of 2022?
No, sir.
Okay. And ma'am, when you gave birth to Ronan, were you at term when you gave birth?
I know I was induced 3 weeks early.
No, it was after Rain was born.
Okay, thank you. Mr. Hill, Ms. Uselton has stated that in this particular matter that you had engaged in sexual relations with her at the time of conception of Ronan. Is that correct? I can't hear you. Did you answer? Mr. Hill?
Yes.
You're not coming through, so. And you heard my question. In fact, had you engaged in sexual relations with Ms. Uselton at the time of conception?
Yes, sir.
Okay. And in this matter, have you been in his life since the child was born?
Much as I could be. We have a lot of different things going on where, I guess the best way to put it is I wasn't able to be around due to a lot of different cases that were going on, a lot of random problems. I don't know too much about it because I was hardly involved. I mean, other than what was said here or there. Like I wasn't face to face talk too much about what was actually going on, I guess.
Okay, well, let me ask you this way. You understand by acknowledging that you are in fact the biological father, that it carries with it certain financial responsibility and obligations. You understand that?
As far as I know, yeah, if it's child.
Well, it might require medical expenses, child support, things of that nature.
Yeah. I have 3 other children that I do the same thing for. I've always had a job. I've always had them under my medical.
Okay, my question is,
understand.
You understand if you acknowledge the paternity of that child that you'll be accepting that responsibility?
Financial standpoint, it shouldn't make a difference. If I'm the child's dad, I'm going to take care of them regardless. Like I'm not worried about financial circumstance. I can take care of that.
Well, do you acknowledge that you're a father?
I mean, as far as I've always been concerned, I thought I was, yeah. I mean, even the circumstance of this situation, you know what I mean? I know I only know as much as I know, and as far as I'm aware of.
Okay. Well, thank you, sir. That's all I have for you. What the court will do in this matter, the court will determine that the child is in fact not issue of this marriage. Court notes it heard the testimony, some of it conflicting, but in any event, even based upon the defendant's own testimony, that if he did engage in sexual relations with the plaintiff, that it would have been only 5 months prior to the birth of the child. So it doesn't appear that he would be the biological father. The court can therefore rule him out as the biological father based upon the testimony of Mr. Hill. What?
Your Honor, I'd like to speak on what's going on, because I feel like a lot of stuff is missing and not being brought up for why I'm involved in the child's life.
Okay. The only question was, were you engaged in sexual relations at the time of conception?
I have never, ever once stated that I was Rain's biological father. Okay, I was brought into this.
That's fine.
So she lost custody of her son because of drugs, Your Honor. We were still married. I was given custody of the child because both the father and the mother were using methamphetamines. DHS and CPS brought me into this and gave me my son because we were still married.
Okay, when you say your son, are we talking about
Rain?
Ronan?
Yes.
Okay.
That is the only reason I am even involved in any of this at all, because I said yes, that I would raise him as my own. Gladrian asked me, told me that my son deserves a good father, and is the only reason I stepped forward. Mr. Hill, from what I know, still uses meth. He is not supposed to be around my father by DHS authority. From the last thing I've ever heard, when anything has happened with the custody of my son, the past in December and in February, I believe, the last court hearings for Miss Usselton, I wasn't even involved. And I should have been, because I have full custody of Rain.
Okay, you have full custody. How do you have full custody?
You
do. DHS.
Okay, well, they can't grant you custody. They can grant you possession of the child, but they cannot grant you custody.
So what has happened between then and now to where I haven't been informed of anything court related to my son? He has my last name. He was given to me under the supervision of DHS.
Okay, sir, let me ask you this, and we can cut this short. Are you seeking to make a custody, again, determination on your son that he should be in your custody?
Yes.
Okay, well, then that will be beyond the scope of this particular hearing. We're going to need to have a separate hearing as it relates to best interest factors, which is much more lengthy. So, and the court is not capable at this point of making a determination that Mr. Hill is the child, because he said he always thought he was, but that's not dispositive. So what the court will do is the court will set a separate hearing, and then we can address all of the issues as it relates to the best interest of the child test.
Can I address one more thing, Your Honor?
Nope. We're going to have a separate hearing. No, we're going to have a separate hearing. You can address anything you want at the separate hearing.
I want to know where my son is now.
Okay.
I haven't seen him in over a month, Your Honor.
Okay, then what you need to do in the divorce case, this case, you need to file a motion for custody, parenting time, whatever.
Shouldn't have to.
Okay. 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 We'll do that, and we'll give you. We'll be in contact with you and set up a hearing date in which we can make that determination. But you're going to have to establish that it is in the child's best interest that the child remain in your care and custody. Okay. You can file the motion before that. We can address it before that hearing, but that will be the parameters of that particular hearing. Okay.
Yes, sir.
Okay. Thank you. We'll be in touch with you and set up a hearing then.
Thank you.
Okay. You're excused. Have a good day.